The point is that the courts are going to bend backwards to hold the corporation in, and you're going to have a hard time after indictment or conviction to change the court otherwise if those basic elements of respondeat superior are met. So, what are the factors in terms of charging a corporation? Number one is going to be the nature and seriousness of the offense. Number two, pervasiveness of the wrongdoing within the corporation, including the complicity of corporate management. The corporation's history of similar conduct, including prior criminal, civil, or administrative penalties, or enforcement actions that have been taken against a corporation. A corporation's timely and voluntary disclosure of wrongdoing, and the corporation's willingness to cooperate. Now, you're always going to have a willingness to cooperate. But one of the factors that can be taken into consideration by the Justice Department as to the nature and extent of your cooperation is whether or not you are willing to waive an attorney-client privilege or other privileged information in the cooperation. So it's not necessarily enough for you to say, I want to cooperate. My client wants to cooperate. We'll do anything you say, but, you know, there's some privileged information that I can't divulge to you. That's going to be used against you. And so a decision has to be made when we're talking about cooperation as to whether or not there's going to be a disclosure of confidential information. Why is this such a dilemma? That is because a decision not to prosecute your client has not even been made yet. You could disclose all this attorney-client privilege information, cooperate with the investigation, and then the U.S. attorney may say, you know what, it's not enough. And you're going to get indicted. Or we're going to have some other type of administrative penalty or some sort of deferred prosecution with respect to your client. That's a big decision to make, and God bless you to be able to make it, because that's a hard decision to make. We are all geared and we are all programmed to maintain our client's confidentiality. And that, in the case that I was discussing with you at the beginning of this talk, was one of the biggest decisions that we had to make with respect to cooperation. Another factor is to analyze the existence and the adequacy of the corporation's pre-existence compliance programs. Compliance programs are established by corporate management to prevent and detect misconduct and to ensure that corporate activities are conducted in accordance with all applicable criminal, civil, and administrative laws. And they should, and they look to see whether or not your compliance program includes voluntary disclosures to the government of wrongdoing discovered. And don't forget, and I'll underline this, they look at your previous compliance programs. It's not enough to say, oops, you caught me, we're changing our compliance programs, please take that into consideration. They want to see whether or not your compliance programs before the criminal conduct were in place. They will look at the corporation's remedial efforts to implement or improve corporate compliance programs. They will look, and this is important, and this is what saved the company that I represented, I think, other than my great legal ability. What were the collateral consequences, including disproportionate harm to shareholders, pension holders, and employees that were not culpable? And what would be the impact arising from the prosecution on them? So you got to take a look at. Many corporations, for example, the pension plans and the people that have pensions are in a trust that actually own part of the corporation. That the pension holders, through their trust, may very well be shareholders as well And so it's really good to be able to take a look at and to demonstrate what the impact of a criminal prosecution might have on innocent persons. The other thing that the government will look at would be the adequacy of the prosecution of the individuals who are responsible for the corporation's malfeasance, and the adequacy of remedies that are civil or regulatory in nature. And that's what I think you must have all heard about deferral agreements. This was during the Christie tenure as U.S. Attorney, entered into with corporate defendants, in which the corporate defendant's prosecution was deferred. And during the deferral period, a monitor was appointed by the U.S. Attorney to monitor the fiscal activities, the rehabilitative activities, and the way in which the corporation conducted itself post-investigation. And, parenthetically, the corporation paid for the time and effort of the monitor that was appointed by the U.S. Attorney's Office. Parenthetically, again, what we did in our case, as we were trying to demonstrate that the corporate entity should not be indicted, is we developed our own plan toward rehabilitation during the time that we were negotiating with the U.S. Attorney, and then presented it to them and said, here's what we're doing. So I wanted to defer the deferral. I didn't want a monitor to be appointed for my client. I didn't want my client to expend money to pay for some guy to come in once or twice a week and basically say, yeah, you're doing fine. So we developed the plan in advance of the negotiations so we can make them and present them during the course of the negotiations. All right, let me shift gears for a moment. And I want to talk about conflicts of interest and the multiple representations of various clients. In criminal cases, and in the most part, that one attorney cannot represent two co-defendants who have been indicted. But what happens during the course of an investigation, such as a grand jury investigation, in which nobody's been indicted, and now you, as corporate counsel, have people coming to you, such as the president, or the vice president, or the fiscal officer, or saying, what do I do? What is it that I should do? In the matter of the state grand jury investigation that was decided by the New Jersey Supreme Court, that issue was discussed in a case in which a corporate contractor involving a grand jury investigation into whether the corporation had committed fraudulent invoices for services to government. And the company arranged for lawyers to represent 3 of its employees and a 4th lawyer to represent all of the other employees that were not considered to be subjects or targets. So there's one lawyer representing a vice president, there's a lawyer representing the president, there's a lawyer representing the corporation, and a lawyer representing everybody else who may have to appear before the grand jury. And the company agreed to be responsible for the attorney's fees and the professional obligations, though, with respect to the representation to the individual employees. So that the company is paying my fees, but I'm representing you. Oh, by the way, part of this agreement was the attorneys were not required to make any disclosures to the company, and the payment of legal fees was not conditioned upon the attorney's cooperation with the company. And the company wrote letters to the company saying, look, we'll pay for these counsel. You're free to hire anybody you want on your own dime, but we're offering you these counsel. And the letter explained that the company retained the attorneys because it recognized that the employee's personal rights may conflict with the interests of the company. They also advised the employees that the company might stop paying the lawyers in its own discretion. The state eventually moved to disqualify the company-retained attorneys before the trial, claiming a conflict of interest. And the Supreme Court was deciding and attempting to harmonize the various RPCs with respect to multiple representations. And those RPCs were 1.8F, 1.7A2, and 5.4C, which basically deal with the issues concerning retainer agreements, multiple representation of parties, and who's paying for the representation. The Supreme Court imposed 6 conditions in a situation in which this type of scenario was preferred by the corporate entity. Number 1, you need the informed consent of the client. Number 2, the third-party payer is prohibited in any way from directing, regulating, or interfering with the lawyer's professional judgment in representing the client, and the lawyer-client relationship remains sacrosanct. Number 3, there is no attorney-client. Number 3 is that there should be no current attorney-client relationship between the lawyer that you're picking to represent the vice president and the corporate entity. So that I'm the corporate entity, I can't choose somebody that's already in my employ in some way to represent the vice president. It's got to be somebody new and independent. The lawyer is prohibited from communicating with the third-party payer, the corporate entity, concerning the substance of the representation of the client, and that includes redacting the legal bills that go to the client, goes to the corporate entity to be paid. Now, just as an interjection here, there is such a thing as a joint defense agreement, which can be entered into and among attorneys representing clients that have similar interests in a criminal investigation. And the Supreme Court did not discuss nor analyze in any way the effect of a joint defense agreement upon the requirement that the attorney representing the vice president should not disclose information to the corporate entity. One of the purposes of a joint defense agreement is to have open communications among several parties and preserve the attorney-client privilege. The corporation has to pay their bills to the attorneys within the regular course of business and consistent with the way that it pays its bills for its own attorneys. And the third-party payer cannot be relieved of its continuing obligation to pay without the leave of court. And the Supreme Court in that decision gave guidance with respect to how these letters that are provided to employees, how these letters should be written in order to provide informed consent concerning this type of arrangement. Now, everybody has a right to their own lawyer. Wheat versus United States is the classic case. It's a Supreme Court case which says that there is a presumption in favor of a defendant's counsel of choice. But if a court can be convinced that there's a conflict, disqualification is almost assured. But a court need not wait until there is an actual conflict before it makes a determination to disqualify a lawyer representing the corporate entity and the individuals that are being investigated. I think the language that the Supreme Court has used is that the court can nip any potential conflict in the bud by disqualifying an attorney because they don't want a prosecution to go through up until the day of trial and then all of a sudden we've got a problem because of a conflict of interest. And the government has standing to make application to the district court to disqualify a lawyer during the course of a representation in order to protect the investigation, to protect the integrity of the prosecution. And there is a hearing which can take place with respect to the prosecution and the conflict of interest. It's under Federal Rule of Criminal Procedure 44C. It's not a summary proceeding, it's a plenary proceeding to determine the nature and extent of a conflict. So remember, I told you I was driving to my client during the course of the execution of the search warrant. What did the prosecutor say to me? The first thing she said to me is, "Who do you represent?" Because she wanted to avoid the conflict. She wanted to avoid the conflict from the get-go. And I certainly didn't want to be boxed out of this case from the get-go as well. It was important to me as to determine who it is that I represent. The best way to determine who it is you ought to be representing in terms of attorney-client privilege is to engage the prosecutor in a dialogue, because they are more than willing to assist and to discuss with you those issues. Now, once you determine who you are representing, what do you do with the people that you don't represent? And I don't mean necessarily getting them lawyers, but you, corporate attorney who represents a corporation, needs to be able to communicate with members of your corporation, with your employees, with your officers, people you don't represent, in a way that you can accumulate information. Because the person with information may not be the president who is your client. So, there is a case called Upjohn Company versus United States, which established what is known as the corporate Miranda warning. The corporate Miranda warning was put into place in order to advise employees and officers that the corporation is the client and therefore controls the privilege and confidentiality of any discussions, of any communications that's provided by the employee or the officer. So that you, as a corporate lawyer, may be going to the person who is the CFO and say, "Give me this information concerning your relationship with the bank, with respect to GE Capital." You have to, at that initial meeting in which you have your senior management, and you're sitting with senior management in a room, you're not representing them all, and they have to know that if they disclose something to you, that if you're not representing them, that the corporate entity has the right